All right, earlier on you saw Natasha Piri there giving us an installment of what was taking place outside court as the arguments in the Phala matter were then being heard inside court, and someone who was watching proceedings inside the courtroom is SABC News reporter Canny Maphanga, who is joining us live now. Canny, let's perhaps start with, the argument around the time and the delays when it comes to this matter then being brought before court. You're hearing, of course, one of the justices raising a concern to say, why did it take about 14 months to then bring this application? At the same time, Advocate Anton Katz as well saying that this is a red herring and a serious constitutional matter.
Well, good afternoon to you and to the viewers at home. Essentially, what we are dealing with here is the EFF's main bid to revive the Phala saga. Of course, they're looking to challenge the rationality of the National Assembly's 13 December 2022 decision to vote against the adoption of the Section 89 independent panel report. And then, of course, in addition to that, they're looking to amend, or the EFF rather is looking to amend the rules that permitted that to take place in the National Assembly. Now, what you've mentioned about the unjustifiable delay, Bongiwe, that speaks to the timeline running up to what brings us here today. Now, we may remember that the decision was taken in December 2022, but of course, the EFF first had an application in March of 2023, if I stand to be corrected on that one, and they also tried to get direct access in the Constitutional Court and they were turned back. Now, after that failed bid for direct access, we didn't hear much from the EFF for some time, and then in February 2024 you saw them bringing this application to the Constitutional Court seeking that particular relief. Now, of course, that is quite a lengthy delay that hasn't been explained in court papers. You saw Justice Tehran trying to probe EFF counsel, that is Advocate Camille Premed, as to why there isn't an explanation from the EFF as to why it took so long to bring this matter to court. Now, we know it's not fully articulated in court here in the arguments, but in the papers, the president charges that he believes there was a political motive because the EFF bought the application just months before we were expected to go to those hotly contested 2024 national and provincial elections. And of course, it would have had serious implications for the president if they were able to revive that bid. Of course, the delay as well presents further hurdles because we now have gone past the 6th Democratic Parliament. They concluded their business, and now we are in the 7th Democratic Parliament. And of course, the question is, if it is remitted back to the 7th Parliament, then what is the implications of that, and what exactly do you do with those previous votes of the 6th Democratic Parliament?
And Kenny, you mentioned this a little earlier on, but I want us to look at the significance of it. The argument that the impeachment rules should be amended.
Yes, essentially we are speaking about the National Assembly rules that the National Assembly is different as an institution, but let's start there, and the fact that their internal processes are for them to decide. Now, you've seen arguments from the respondents stating that there needs to be a separation of powers principle that takes place here, because if the EFF is successful in their bid, then Judiciary will then be effectively dictating that a third party can now decide what happens in an impeachment process, and we know that is a political process decided by politicians in the National Assembly. So the suggestion is, instead of attacking that process, rather find remedies in law to guard against the abuse of power that the EFF contends happened. Because remember, they're arguing that in this particular decision that the ANC used their majority, because remember in the 6th Democratic Parliament they were still a majority party, they used their majority to vote against the adoption of the Phala report, and of course effectively shielded the president from any further accountability with respect to the National Assembly, and by effect then didn't act in accordance with their duties as the National Assembly.
Now, Kenny, where are we when it comes to this particular process in court?
Well, currently we are hearing submissions from the ANC that is represented by Senior Counsel Advocate Tembega Ngwaitowi, who has emphasized the importance of an impeachment and not to take it lightly, and emphasized that when the National Assembly looked at this particular report and found that it was fundamentally flawed, they looked at the scope, they looked at the different interests that were looked at in the report and found that it was not fit to proceed with this particular report in the National Assembly, and then of course voted against it. It is against that backdrop that the ANC is arguing the decision was lawful and it was rational, and they couldn't proceed with a report that had quote-unquote cherry-picked what was going to be investigated, and of course, according to the President and the ANC, was quote-unquote fundamentally flawed.
All right, Kenny, I'll let you go back inside. Thank you very much for that update. That's Canny Maphanga, the SABC News reporter, watching the developments inside the Constitutional Court for us, as you heard there. The lawyers for the ANC making their submissions. We'll continue to keep you updated. Remember, also outside, we are expecting EFF leader Julius Malema to also address the members that are gathered outside court there as well, and we'll keep you updated as well.